Vicky, what are you suing for? How much?
£1,432.
What's that for?
That's for the £133 outstanding for December's rent, and then January, February and March rent, as there was no notice at all given.
You say that insufficient notice was provided, even though she hadn't attended at the beginning of January. In fact, she hadn't attended much after December at all. You say her non-attendance is insufficient notice. She had to specify that she was no longer going to attend, even if that was during the first 3-month period, correct? And so, consequently, she isn't just liable for the first 3 months, but the 6 months specified in the first part of the clause of that contract. Yes?
Yes.
I now come to Julie, your response. You've a counterclaim.
Yes, I do.
This counterclaim, it seems to me, was triggered around the same time that this argument, this very violent argument, took place, when, having looked on Facebook, you realised what?
That she had been using my equipment without my express permission, and she had used everything that I had down there.
Now, where in the contract that you have between you does it specify that Vicky is not to use, neither is she allowed to use your personal equipment?
It isn't.
So what's the problem?
I did ask her not to touch them.
How much are you suing for and what for?
£1,415 for collective dog grooming equipment.
£1,415, correct?
Yes.
That is almost the exact amount that she claims you owe her in rent. Interesting. A coincidence, perhaps. Why does she owe you £1,415 when you've got it?
Because the equipment has been used. Everything I brought down there was brand new. And obviously on checking the equipment, it is not as I left it.
Well, this is what your sister says. Julie showed me her equipment afterwards, which was usually spotless. She really takes care of it. It was all dirty and full of grime. Julie should never have let this happen. And she says various things about the situation being ridiculous and getting to this point. Is that the state of the equipment?
That is the state of my equipment now.
Understood. Can it be cleaned?
I don't know until I send it off to a sharpener. And it's going to cost me quite a lot of money to send it off or to replace it.
Well, I've looked... Does that look like it needs to be replaced or can it be cleaned?
It can be cleaned and sharpened. An average price of around £6 for scissors and £6 per blade.
Or £10 and £6.50.
£10 and £6.50?
£10 for scissors, £6.50.
How many scissors have we got?
I have 7.
Were there 7 scissors?
There were 7 pairs of scissors in the salon, yes.
Now, Vicky, you rented a space to Julie in your business. You drafted a very important clause in that contract, the last of the clauses, in fact, which specified, on a plain reading and understanding of it, that the first 3 months were to be a trial period and that Julie was to give you notice if after that 3 months, 3 months ending on the 31st of January, she was to notify you if she no longer wanted to work with you. As a matter of fact, in this case, it was quite clear that after December, Julie failed to attend at all during the month of January. Objectively, that means me applying my mind. That should have given you all of the indication you needed that Julie no longer wished to pursue her interest in the business and that you were entitled to come to a concluded view that the 3 months hadn't worked out and consequently it was strongly implied she was no longer interested in carrying on. In my judgment, therefore, you are not allowed to sue for the further 3 months. Your application is limited for the amount that she failed to pay you in December, which was £133, and the £433 that she failed to pay you in January. The total amount you're claiming for is £1,432 in unpaid rent. This court awards you £566. You are absolutely bound to pay the 3-month trial period. I have no difficulty coming to that conclusion whatsoever. What you ought to have done is to have made clear that she needed to specify that in the event that she didn't want to continue, she had to put that in writing. Madam, your counterclaim is for £1,415 for dog grooming equipment. I dismiss that value entirely out of hand. I do so because you've got it back and because I'm perfectly satisfied that it can be repaired. Let's say that those scissors were used, there are 7 of them, and they need sharpening. And I take the view that there is a possibility, because they were there for 3 months, and I am more sure than not that at some point those scissors may have got used, they're going to cost £6.50 to get sharpened. And there are 7 sets of scissors. I take the view that that's your financial responsibility to sharpen those scissors. Your claim is for £1,415. The order of this court is for £45.50. The order of this court is £566 for you and £45.50 for you.
Thank you.
Vicky won part of her case and was awarded £566. Defendant Julie was awarded £45.50 of her counterclaim. Let's find out how both parties felt about the judge's ruling.
Well, I just think it's ridiculous you're claiming for the equipment that wasn't used.
Unfortunately, my equipment was disgusting, and I keep my equipment pristine. And
just don't get many bookings.
my equipment is pristine, and it's cleaned every week, and you're just this vile person, horrible manipulator. Don't know if I'm going to go back into dog grooming because of my health situation at the moment.
In regards to renting out space from the salon again, I don't think I will be doing it anytime soon. No, I think I've learnt my lesson.
Don't be stupid. Stay and watch the best Judge Rinder moments. And I'm talking. Understood? Don't be a moron. Subscribe to Judge Rinder YouTube channel. Right now. That's an order.